The Act appears too fixated on the idea of pre-litigation mediation. This is perhaps a real howler in the whole of the Act. Pre-litigation mediation is a mediation undertaken for settlement of disputes before filing a suit or proceeding of civil or commercial nature in any court or tribunal. Simply put, a pre-litigation mediation, as the term suggests, is a mediation that happens before litigation. The original bill, that is the bill that was introduced in Rajya Sabha in December 2021, proposed compulsory pre-litigation mediation. A compulsory pre-litigation mediation makes mediation a precondition to any suit. So if you were to file a suit, say of civil or commercial nature, before any court, you have to attempt mediation first. Mandatory. Something very similar to Section 12A in the Commercial Courts Act 2015, but even broader. In a way, mediation takes over the entire dispute resolution spectrum in the country as the first mandatory step. Almost everyone ends up mediating in civil and commercial matters. A big revolutionary move. But that proposal met with some serious opposition, rightly so in my opinion. The element of compulsion militates against the very consensual essence of mediation. Mediation should be one of the options available to the parties when they encounter a dispute, not the first compulsory step in any dispute resolution process. For a variety of reasons, mediation may not be best suited for all the disputes. I'm not forgetting that only participation is compelled, not the settlement. Now, even if we make mediation compulsory, do we have the right infrastructure for that? Enough space, enough facilities, enough qualified mediators? Simply no, not at the moment. Again, does mediation has that level of public awareness and acceptance so that litigants are happy to go through it? I think the answer is no again. Not yet. I guess the drafters understood these reasons, and although it was highly touted as a unique Indian idea, compulsory element of pre-litigation mediation was withdrawn. Now, the amended bill and eventually the Act make pre-litigation mediation optional. Withdrawing the compulsory element from pre-litigation mediation makes sense. But I don't think keeping the concept of pre-litigation mediation in the Act, albeit as an optional one, is a smart move. Let's see. A and B are Indian residents who are parties to a commercial dispute. They go for a mediation and settles the dispute and enter into a mediated settlement agreement. How do you label that mediation? A normal domestic mediation, which it is, or a pre-litigation mediation because it is done before potential litigation? How do you, at least in such circumstances, differentiate mediation from pre-litigation mediation? Even if we can, what's the objective? The Act says that parties will have to consent to pre-litigation mediation whether a mediation agreement exists or not. Won't a post-dispute consent to mediate amounts to a mediation agreement to mediate existing disputes? What's the difference? Why have we retained the idea of pre-litigation mediation, even if it is an option? When I read it, at the best, it is confusing and crafty. More likely, this could be a remnant of the original provision on mandatory pre-litigation mediation, retained in the Act because the drafters are too fixated with the idea of pre-litigation mediation. We could have done with a lot more clarity on that.